Good afternoon, everyone. I'm Jen Nevis, and welcome to our IR webinar session. Through the investigation and detective management of PNP, crime statistics revealed that from January to May 2018, there were 2,962 reported cases of rape. With these stifling numbers, how can we ensure that violence and discrimination cannot blight our lives and hold us back from playing a full part in the workplace, society, and economy? With the enactment of the new law, how does the Safe Spaces Act protect you? How does it protect everyone from sexual harassment, both in physical and online spaces, and not just by persons in authority? Friends, we are thankful enough that we have our speaker for today. He is a graduate of University of the Philippines, Diliman, taking up Bachelor of Arts in Political Science, magna cum laude. He then took up his Juris Doctor degree at the same university. He has been involved with the Safe Spaces Act, IRR Technical Drafting Committee as CSO representative. At present, he is a lawyer at Centro ng Alternatibong Ingap Panligal, or also known as Saligan. Friends, join us to welcome Attorney Juan Carlos J.C. Tejano for this afternoon's IR webinar session.
Hi, good afternoon everyone. I'm J.C. Tejano as introduced by my good friend Jet. For today, we will discuss the Safe Spaces Act with particular focus on sexual harassment in the workplace. I presume this is what many of us want to know more about, and what we're also discussing in our own workplaces. We will start with an introduction of the Safe Spaces Act, and then we will go into how this relates to the old Anti-Sexual Harassment Act of 1995. And we will also look into the duties and liabilities of employers and even employees under the Safe Spaces Act, and also some of the more important provisions. We're trying to keep this into 30 minutes. So we will focus more on the salient provisions of the law. Okay, so as many of you probably already know, there is an Anti-Sexual Harassment Act that was passed in 1995. It punished sexual harassment with particular focus on work, education, and training-related environments. But sexual harassment under this law could only be committed by superiors, teachers, coaches, or co-employees. And the definition for sexual harassment under this law was rather limited. It focused on superiors, employers, teachers who demand, request, or otherwise require any sexual favor from the other, regardless of whether the demand, request, or requirement for submission is accepted. So before this law, what governed sexual harassment in the Philippines was the general law of the revised penal code. And mostly ang pumapasok lang doon is unjust vexation or grave scandal. Before this law in 1995, you could only expect protection or safety from sexual harassment really in private spaces, especially for instance in your house, in your car. And then this law came into effect in 1995, and it really changed the rules. And it prohibited for the first time by special law sexual harassment in workplaces and in schools. 14 years later, in 2019, the Safe Spaces Act, or RA 11313, was passed. And this law radically changed the regime on sexual harassment in the Philippines. It expanded very broadly our concept of sexual harassment. Before, like I said, safe spaces or spaces of safety from sexual harassment used to follow property, your house, your car. And then under the Anti-Sexual Harassment Act of 1995, safe spaces were provided in places, particularly workplaces, education, and training-related environments. Under the Safe Spaces Act, it's practically created new spaces of safety from sexual harassment, which now follow not property, not places, but persons. Each one of us under the law now has a personal safe space or a personal space of safety from sexual harassment, which is practically inviolable unless we consent. So any act under the Safe Spaces Act, any act that is unwanted and uninvited and is sexual in nature, committed against us practically anywhere, will count now as sexual harassment. The public spaces that the law covers are streets, online spaces even, workplaces, and schools. When we really think about it, I used radical only in the sense that it changed the legal regime. But really, when we think about it, there isn't anything earth-shattering under this law. Matagal nating alam no, na bawal ang bastos sa Pilipinas. Masama ang bastos sa Pilipinas. And in fact, it's almost ridiculous to say no, na sexual harassment or pambabastos can happen only in schools and workplaces. This law only conformed our legal regime on sexual harassment to what is already actually frowned upon in our culture, which is pambabastos. So very simply, under this law, na bawal ang bastos, and it is very aptly called bawal ang bastos law. The law also graduated penalties for severity and repetition, and it expanded liabilities of employers and heads of educational and training institutions. Not only liabilities, but also the duties of employers and school heads. And it also assigned local government units and national government agencies as duty bearers. The law creates two new crimes. The first one is gender-based streets and public spaces sexual harassment. It's a mouthful. We can just say it's GSH in public spaces. That's it basically. The second one is gender-based online sexual harassment, or which is what I like to call GOSH, gender-based online sexual harassment. The first crime has essentially 4 elements. I won't show you the provision anymore, no, mahaba siya. The 4 elements are very basically, number 1, conduct is unwanted and uninvited. Number 2, the conduct consists of sexual actions or remarks. Number 3, it's committed against any person, so it has to be directed against a person. And number 4, it's committed in a public space. So you will notice under this law, there is no more requirement for a demand, a request, or even a sexual favor. Any act that is by nature sexual, or even any remark that is by nature sexual, will count as sexual harassment as long as it is unwanted and uninvited by the recipient of the act or remark. It has to be directed against a person. One thing that we need to note under this law, misogynistic, transphobic, homophobic remarks are by provision of the law now also criminal if they are unwanted and uninvited and committed against a person or directed against a person. So what are public spaces, which are the only places where you can commit this crime? The law enumerates them. I just want to note 2 important places here. The first one is buildings. The law makes no distinction as to what kind of building it is. So it can be private, it can be secluded, it can be inaccessible by the public, but it is by law counted as public space. So, meron mga nagtatanong sa amin dati, no, pag nangyari ba to sa bahay ng pinsan mo, will that be GSH in public spaces? I would say so, yes. Kasi because it includes buildings. Another item in the enumeration is this last one. This was included in the IRR of the Safe Spaces Act, which is all other areas, regardless of ownership, openly accessible or offered to be accessed by the public. So the enumeration is not exhaustive. It includes any other public space. The second crime created by the Safe Spaces Act is the gender-based online sexual harassment, or GOSH. GOSH refers to an online conduct targeted at a particular person that causes or is likely to cause another mental, emotional, or psychological distress and fear of personal safety. That alone is broad enough to include several acts online. And in fact, the law in particular, and I guess this has to be highlighted for many of us, now prohibits the unauthorized recording and sharing of any of the victim's photos, videos, or any information online if it's not consented to. Maybe one thing that we need to note is this can also be punishable under the Data Privacy Act. But this law adds a new crime under which you can be prosecuted, or for which you can be prosecuted. And that is GOSH, gender-based online sexual harassment. So also impersonating identities of victims online is GOSH. Posting lies about victims, so yung fake news to harm their reputation. Even filing false abuse reports to online platforms to silence victims is considered GOSH. Another definition for GOSH is any sexual harassment act, including unwanted sexual remarks and comments, threats, uploading or sharing of one's photos without consent, video and audio recordings, cyber stalking, and online identity theft. Again, sexual remarks and comments under the law expressly include misogynistic, sexist, transphobic, and homophobic remarks. Okay, so we go now into the meat of the discussion, really, which is sexual harassment in the workplace. What is the impact of the Safe Spaces Act on the old Anti-Sexual Harassment Act? Does it repeal the old Anti-Sexual Harassment Act of 1995? Now, the quick answer is no. The crime of work-related sexual harassment under the old Anti-Sexual Harassment Act has elements which are very much distinct from the elements of gender-based sexual harassment in the workplace under the Safe Spaces Act. So I said earlier, the new law, Safe Spaces Act, creates only two crimes. It does not create a new crime for sexual harassment in the workplace. What does that mean? That means that gender-based sexual harassment in the workplace cannot be prosecuted as a crime itself. It will be prosecuted as a crime under the broader definition of the first crime, which is GSH in streets and public spaces. So, kung criminal prosecution siya, doon siya mag-fall under sa GSH in public spaces. Unlike the old Anti-Sexual Harassment Act, which punishes work-related sexual harassment as a crime itself. Under both laws, however, the administrative sanctions for work-related sexual harassment, or SH in the workplace, are left to the discretion of the employer. So what does that mean? You can provide for suspension, or dismissal for sexual harassment in the workplace under the company policy. GSH in the workplace under the Safe Spaces Act, although it is not defined as a crime, is nonetheless defined for purely administrative sanctions in the workplace. So this is the definition. Baka there is no use in reading this to you. Maybe you can just refer to the definition under the law or the forthcoming IRR. But we can look at the common elements of this. Before that, so GSH in the workplace, unlike sexual harassment or work-related sexual harassment under the old Anti-Sexual Harassment Act, may now be committed by anyone. You'll notice yung sexual harassment or GSH in public spaces, yung sexual harassment under the old Anti-Sexual Harassment Act could only be committed by employers, teachers, superiors. And then this Safe Spaces Act comes in, and it now allows for the prosecution of anyone who commits any unwanted and uninvited sexual actions and remarks against anyone. So, under this law, GSH in the workplace may be committed by peers, by a subordinate against a superior officer, by co-employees, by contractual workers, by anyone. And workplaces under the Safe Spaces Act, particularly the IRR, include all sites, locations, spaces where work is being undertaken by an employee within or outside the premises of the usual place of business of the employer. If this definition were adopted, that means that workers who work from home will have their home protected as their workplace. So some of the common elements of GSH in the workplace under the Safe Spaces Act are: number one, there should be unwelcome conduct. Number two, it can be done verbally, physically, or through the use of technology. Ano yung sabihin? Pwedeng email exchange, yung sexual harassment. And number three, it has to be committed in the workplace. GSH in the workplace under the Safe Spaces Act can be committed via three modes. The first one is an act of sexual nature that has or could have a detrimental effect on the conditions of an individual's employment or education, job performance, or opportunities. So basically, any act of sexual nature na may impact sa labor conditions nung worker. Number two, conduct of sexual nature or conduct that is based on sex, which is unreasonable and offensive to the recipient, and which affects the dignity of a person. Number three, any conduct that is pervasive, which creates an intimidating, hostile, or humiliating environment for the recipient. So this is similar to the old Anti-Sexual Harassment Act, which provides na sexual harassment then if it results in an intimidating, hostile, or offensive environment. So notice, merong bago dito, anything that affects the dignity of a person committed through conduct of sexual nature or conduct based on sex, that will amount to sexual harassment under the Safe Spaces Act. So if you compare the two laws, they are really different. Work-related sexual harassment under the old Anti-Sexual Harassment Act of 1995 is very different from GSH in the workplace under the Safe Spaces Act. You can just look at the slide. What does this mean? And actually, we will notice from the definition here, from this table, that work-related sexual harassment under the old law is very specific. It requires very specific conditions, and it can be committed by a limited number of people, only by employers and persons of authority, influence, or moral ascendancy, or co-employees. Now, under the Safe Spaces Act, it can be committed by anyone. And the definitions are much broader. So that means we have a sphere of conduct which we can designate as GSH in public spaces or GOSH, which are the crimes or which constitute the crimes under the Safe Spaces Act. And within this sphere of conduct, you have GSH in the workplace, which is more specific than the broader sphere. So, for purposes of criminal prosecution, there is no crime. There is no crime for GSH in the workplace. You have to designate it as GSH in public spaces or gender-based online sexual harassment. But for administrative sanctions, you can designate it as GSH in the workplace. But since the old Anti-Sexual Harassment Act was not repealed, within GSH in the workplace, there is an even more specific set of actions or remarks or conduct, basically, which may amount to work-related sexual harassment. What does this mean, practically? Parang tayong naglalaro ng dito, ng ideas. Now, what does this mean practically? Let's say an employer requires an employee na maghubad para makuha niya yung promotion na hinihingi niya. Okay? Obviously, that is work-related sexual harassment under the old Anti-Sexual Harassment Act. It also amounts to gender-based sexual harassment in the workplace. And it is also a crime. Firstly, as work-related sexual harassment itself, and secondly, as GSH in public spaces, or gender-based sexual harassment in public spaces. Question, can you prosecute the employer for the two crimes? Yes. Yes. So the employer will now be liable criminally for two crimes under this overlap between the Safe Spaces Act and the Anti-Sexual Harassment Act. How about if a subordinate commits sexual harassment against a superior or the employer? There is no work-related sexual harassment that was committed because it's not covered by the definition of Anti-Sexual Harassment Act. But there is gender-based sexual harassment in the workplace. Is that a crime in itself? No. Like I said, it will have to be prosecuted as a crime under the designated name of gender-based sexual harassment in public spaces. Okay. Do employers, so in defining in our company policies, in our employee manuals, in defining sexual harassment, do we have to spell out these overlaps? Or do we have to be mindful of these overlaps? Not really. The management has the prerogative to define what is sexual harassment as long as that prerogative is exercised not to limit the definition under the Safe Spaces Act. What does that mean? You can expand beyond the definition of sexual harassment under the Safe Spaces Act. It can be very simple, actually, in our own company policies. Okay, so what are the duties of employers and persons, yung AIMs, persons of authority, influence, or moral ascendancy? What are their duties? In a nutshell, their duty is to prevent, deter, or punish gender-based sexual harassment in the workplace. This entails 4 duties, 4 sub-duties. The first one is to disseminate and to educate their employees, their subordinates, on the Safe Spaces Act and on sexual harassment. The second one is to institute preventive measures. What are these? These are only examples na pwedeng iba pang preventive measures, pero the IRR and the law recommend seminars on basically anti-sexual harassment seminars, and also gender sensitivity trainings, and maybe also trainings on sexual orientation, gender identity and expression. Number 3, the Safe Spaces Act requires employers to have a code of conduct or workplace policy, and also a CODI, or a Committee on Decorum and Investigation, or any independent mechanism to punish employees or penalize employees and other persons in the workplace who commit sexual harassment. Actually, the last two, meron na yan under the old Anti-Sexual Harassment Act. So the expectation actually is the employers, businesses, establishments, workplaces which have been there even before the Safe Spaces Act should already have their own codes of conduct or anti-sexual harassment policies and their own CODIs. I'm sure many of you already have your own policies and CODIs. So the code of conduct under the IRR, the forthcoming IRR of the Safe Spaces Act, requires all employers within 150 days. The IRR requires all employers within 150 days from the effectivity of the IRR to formulate a code of conduct in consultation with workers or the union, if any, in workplaces. It has to define GSH, its coverage, forms, classifications, appropriate penalties, when and where it may be committed and by whom. It has to specify the procedures in the filing of cases, investigation, and resolution, and appeal. Now, that will be the basis of the functions of the CODI. It will specify the functions, responsibilities, composition, and qualifications of the members of the CODI, including the penalties on CODI members who do not perform or inadequately perform their functions. To the extent possible, employers may also include the provision of support, especially for victims of gender-based sexual harassment, including, among others, psychological or psychosocial counseling services, or referral to such services and assistance in the filing of administrative, civil, and/or criminal cases. We should compare this with the provision under the Mental Health Act, IRR, which requires employers to develop appropriate policies and programs, particularly in identifying and providing support for individuals at risk. Victims of sexual harassment can be categorized as individuals at risk because of the experience of trauma, and facilitate access of individuals with mental health conditions to treatment and psychosocial support. Nonetheless, local government units are actually required under the law to provide, when necessary, facilities or access to psychological counseling and other remedies. So, pwede ang mangyari, the employer can refer or can facilitate access to psychosocial counseling or psychological counseling through the or with the help of the LGUs. Okay, so the CODI. The CODI will be the independent internal grievance mechanism, which will act as the main body in the investigation and resolution of cases involving GSH in the workplace. There should be at least one representative from the management, employees from the supervisory rank and file employees, and unions or employees association, if any. So the representatives of the workers have to be selected among themselves and by vote. The employer may include other groups in the CODI as may be applicable. That might be useful, especially for establishments na puro lalaki. Why? Because of the next requirement, na every CODI shall be headed by a woman, and not less than half of its members shall be women. This requirement under the law, so it's unavoidable. All members of the CODI shall undergo training on gender sensitivity, gender-based violence, SOGI, and other GAD topics as needed. The CODI shall observe due process and investigate and decide on written complaints within 10 working days or less upon receipt of the written complaint. 10 days na lang ho no, ang pwedeng itagal ng proseso ng pagdedesisyon ng mga reklamo sa CODI. But what does this mean? Does this mean that the entire procedure has to end with the CODI? No, and precisely the IRR provides that the 10-day period will not include the period of appeal, which should be available to either party. So parang meron lang initial determination yung CODI of guilt, and there can be an appellate process provided under the Code of Conduct. The CODI shall ensure the protection of the complainant from retaliation without causing displacement, disadvantage, diminution of benefits. It shall also guarantee gender-sensitive case handling. Okay, liabilities of employers. Under the old Anti-Sexual Harassment Act, the employer or head of office will only be solidarily liable for damages arising from the acts of SH or sexual harassment if the employer or head of office is informed of such acts by the offended party and no immediate action is taken. Now, very specific requirement. Kailangan yung offended party mag-i-inform sa employer or head of office and no immediate action is taken. So, ano ba ibig sabihin ng immediate action? It can be very broad or very lenient. Under the Safe Spaces Act, new liabilities have been designated or have been assigned to employers and heads of offices. Now, they will be responsible for, number one, non-implementation of their duties. So, kapag meron silang hindi ginawa dun sa apat na sinabi ko kanina, dissemination, preventive measures, code of conduct, CODI, they will be liable under this law. And also not taking on reported acts of gender-based sexual harassment. Not taking action on reported acts of gender-based sexual harassment committed in the workplace. Now, you'll notice now, there are two terms used under the law, complaints and reports. They're different actually, and when we formulated the IRR, this is the perspective that we use, and this is the understanding that we had in differentiating between a complaint and a report. This is crucial because if a complaint is filed, the CODI has to decide on the complaint within 10 days. But if only a report is filed, the employer will be liable only if no action is taken on the report. Anong difference sila? A complaint is filed only by the victim of gender-based sexual harassment. A report, on the other hand, can be filed by any person, to the employer, agent of the employer, or the CODI itself. So the complaint must be made in the victim's own name. It initiates prosecution or investigation and immediate action from the employer. Meanwhile, the report only initiates investigation, not really yung prosecution or the decision-making process of the CODI. And it has to be decided within 10 days. Okay, last, I think 3 slides. So under the law, employees and co-workers also have duties. This is unlike the old Anti-Sexual Harassment Act. Now, under the Safe Spaces Act, employees and co-workers must refrain from committing acts of gender-based sexual harassment, discourage the conduct of gender-based sexual harassment in the workplace. Number 3, provide emotional or social support to fellow employees, co-workers, colleagues, or peers who are victims of gender-based sexual harassment. And lastly, report acts of gender-based sexual harassment witnessed in the workplace. So under the new law, there is a duty to report. In fact, not just a duty to report, but a duty to support under the new law. And we need to note that although there is no crime if these duties are not fulfilled, we need to note that non-compliance may result in civil liability for damages under Article 20 of the new Civil Code. Ano yung civil liability? Pwede kang maging liable for danyos. Danyos, kung hindi kung hindi mo gagawin ito. And it results in damage to the victim of gender-based sexual harassment. Okay, other provisions, other important features of the law. There is a routine inspection. I think the DOLE will come next. So there will be a routine inspection by the DOLE for the private sector and the CSC for the public sector, which should be spontaneous, random, unannounced inspections to ensure compliance of employers and employees under the law. Victims may institute an independent action for damages, basically a civil suit, even with the pendency of the proceedings for any criminal prosecution or administrative prosecution. And when it is committed by other persons, meaning not the employer, the employee, siguro yung bumibili doon sa isang store na binastos yung cashier, the workplace, specifically the employer, or the person in authority with influence or moral ascendancy, should ensure that assistance is given to the employee as mandated in the company's policies and supervised by the CODI and or HR. Okay, last slide. So confidentiality at any stage of the investigation, prosecution, and trial of any offense under this law, the rights of the victim and the accused, if the accused is a minor, shall be recognized, particularly their right to privacy. In all cases of GSH, the confidentiality of the records on the victim and when the accused is a minor will be protected. A restraining order, where appropriate, the court, even before rendering a final decision, may issue an order directing the perpetrator to stay away from the offended person. So TRO, basically. At a distance specified by the court, or to stay away from the residence, school, place of employment, or any specified place frequented by the offended person. Similar, akin to temporary protection order or permanent protection order under the anti-vouching law. Okay, so that's it for the Safe Spaces Act.
So we open the floor to our members for online today for questions, clarifications. You can shoot your questions to Attorney JC and he will answer your questions. So we are waiting for our questions. So first question here. Can you provide us with a copy of the IRR or draft of the IRR?
Maybe the appropriate answer is to give you an update on the status of the IRR. Lagi ko sinasabi kanina forthcoming because I think the PCW is still waiting for signatures of some secretaries. The target, I believe, is by end of February. The IRR should be signed and published already. So technically, I cannot provide you a copy of the draft IRR because yon ay hindi pa public record as of the moment dahil it is still undergoing signatures.
Thank you so much.
Maybe you can actually baka may advance copy sa PCW website. Maybe it's better you download it through that online portal.
Thank you so much, Attorney JC. We proceed to our next question. In terms of reporting, how do we handle if the incident was reported but the actual victim doesn't want to file the complaint?
Okay, this is tricky, actually. There was a question when we were formulating the IRR. If the prosecution of gender-based sexual harassment under the Safe Spaces Act can proceed even without the participation of the victim. I think everyone agreed eventually na it will be impossible. Why? I said earlier, there is a key element to gender-based sexual harassment under the Safe Spaces Act. And this is the first element actually. It has to be unwanted and uninvited. So how can anyone, other than the victim, testify or attest to the conduct being unwanted and uninvited? I would say from a procedural point of view, malabo. I don't think it's possible. No? So, yung conclusion ng drafting committee ng IRR, the report, any report coming from a non-victim of sexual harassment will only initiate investigation, but not actually administrative prosecution. So it will really require the participation of the complainant. Kahit affidavit lang or a statement basically na hindi niya ginusto o hindi niya inimbita yung ginawa sa kanya.
Thank you for that, Attorney JC. We proceed to our question. What are the acceptable evidences of verbal sexual harassment?
Marami. Testimony. For instance, maghihiring yung CODI. So we're looking at the CODI, CODI na perspective. Maghihiring yung CODI na ipagte-testify yung mga nakakita nung nangyaring verbal sexual harassment. In fact, the complainant's own testimony should suffice, especially if the act or the remark was committed in a private place. And we know that sexual harassment usually happens in secluded private places. So the testimony of the victim alone should suffice. Also, affidavits, statements should also suffice as to evidence for verbal sexual harassment.
Next question, what if a company has several branches? Is the company required to have CODI for each branch?
Okay, good question. The requirement is for the employer. Anong ibig sabihin nun? If there is only one corporation and it has several branches, or one company lang and it has several branches, the requirement is only for the company, the main office, to have the CODI. Kasi yung branch, wala siyang sariling entity. Baka magkakaroon lang ng technicality doon kung yung branch ay actually an entity of itself and is actually an employer of itself. But right now, under the old Anti-Sexual Harassment Act, ganun na nangyayari. Kung may branches, main office yung merong CODI.
In the interest of time, we will be accommodating only 3 questions.
Okay.
Can we file an admin case for both GSH and anti-sexual harassment of hearing employees?
It depends. So administrative case, no? I presume this is a private sector. Okay? It depends on it depends on the code of conduct of the company. Kung hiniwalay pa rin nung company sa code of conduct niya or sa anti-sexual harassment policy nila, magkaibang offense yung GSH and yung work-related sexual harassment, then yes, it's possible. As long as they have different elements.
Last 2 questions. How does this translate on the employer's perspective? What if the employee who committed the violation and was terminated is the one who violated this and has been spreading the word about how the process was handled by the employer?
Teka, parang siya, compound question. How does this translate? Okay, what if the employee committed the violation and was terminated? The one who violated this. Violated what? And has been spreading the word about how the process was handled by the employee. If you mean it violated the rules on confidentiality, okay? So I see a scenario, kunyari, na meron ngang accused of sexual harassment, tapos nagsalita siya publicly about the case after termination. Kapag na-name drop niya yung pangalan ng complainant, that is a violation of the rule on confidentiality under the Safe Spaces Act, and more so that might constitute a criminal violation under the Data Privacy Act. Kung sisiraan niya yung employer niya, that might constitute libel or oral defamation, no? Depende, no, doon sa manner, no, or content ng kanyang paninira, no, against the employer.
Last question. Is there a period of filing? And what if an incident happened 6 months ago? Can an employee still file for a case?
Yes. There is a period. There is a prescriptive period, no, for filing the case, no, and unfortunately hindi ko siya memorize. Mas maganda tingnan natin yung batas. Nasa batas mismo, no, yung prescriptive period. But if I remember correctly, in particular, sexual harassment in the workplace under the Safe Spaces Act prescribes in 5 years. No? So yung 6 months, I'm pretty sure it's covered.
So I think that would be all for our topic on the Safe Spaces, the IRR of Safe Spaces Act. For the questions, we can still accommodate them. Just email us or text us through our number for TMAP phone. At this point in time, we would like to thank Attorney JC for his time. And now we move on to our next topic.
Okay, thank you.